Hey, Greg, you're on the air. Go ahead.
Okay, can you hear me?
Yes.
Okay, my question is, my rent's due first every month, and some months I get paid every 2 weeks, and I don't have it on the first. So by the second, my landlord puts a letter on my door, 3-day eviction, and he tells me if I don't have it by the third day, then he sends paperwork to the court, and then I'll have another 24, I think he said 24-hour eviction, but I'll have to have the rent plus an additional $275 court fee. Is that
okay?
Right?
So Greg, listen.
So is there?
No, Greg, it is not. It is not right. So we're going to take a minute to break it down, okay? Because we have Rob Solomon, my landlord tenant attorney, with us today. So Rob, the first thing he said is proper. His rent is due on the 1st. Day number 2, the landlord puts a 3-day notice to pay rent or vacate. Step number 1 is correct.
That is correct.
And so it gives the tenant 3 days in which to pay rent or vacate. During that 3-day period, the landlord must accept the rent if the tenant pays it in full.
Correct.
All right. On day number 4, if the tenant has not paid rent, the landlord, if he wanted to do so, could begin an eviction process. How long would that process take?
Okay, so he's going to have to get served with a 5-day eviction summons for complaint. So the issue isn't that you get a 24-hour notice at that point. You get served with a complaint by a process server, and you will then have 5 business days to answer that complaint. And only if you fail to answer it or put money in the court fund would something immediately happen thereafter. And the immediately thereafter would be he would apply for a writ of possession, and that's where the 24 hours that he's talking about comes to play. They put it on your door, and you have 24 hours to vacate.
So, Greg, the 24-hour to vacate is correct, but it happens at the end of the court proceeding, which is going to be at least 15 days, could be longer. But when a judge does finally grant the eviction to the landlord, the judge gives them a writ of possession that goes on the door. It tells the tenant they got 24 hours to move out. And if 24 hours later the landlord shows up with the sheriff to keep the peace, and they will put your stuff on the curb. Greg, does that answer your question for you?
Yes. The only one other thing is if it goes through actually gets the papers to the court, files it, is it true that I'll have to pay an additional $275 court cost on top of my rent?
So when people apply for an eviction, they're capable of the prevailing party, which if the landlord ultimately got an eviction, he would be the prevailing party, could get the court costs included to be paid back and any attorney's fees. So the answer to that is yes, but generally speaking, all the landlord cares about is making sure that you vacate the premises. So as a practical matter, I'm much more, if I'm representing a tenant, I'm much more concerned not about the $275, but about the fact that they could potentially be evicted.
Very good.